Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have Christy Carpenter here with us to talk about the role of limited license legal technicians in a family law case. Hey, Christy, how you doing today?
I am doing wonderful. I'm very grateful for the opportunity to talk about this.
Oh, this is going to be fun. So before we talk, just can you tell us a little bit about yourself?
Sure. I began my legal career as a paralegal in 1995. My first job was with the King County Bar Association, a legal services agency, helping low-income people do their own divorces. I gradually moved up, worked for a boutique law firm, worked for a large family law firm in the Puget Sound area. And then I became licensed as a limited license legal technician in 2016, opened my own firm in 2017, and joined Pacific Cascade Legal last year.
I love it. Well, then you're the perfect person to talk to about this. And I'm just going to start with the obvious, start with the beginning question. Could you tell us just what exactly a limited license legal technician is?
So I think I like to give the analogy that a triple LT, which is what we call it for short, is similar to a registered nurse practitioner in the medical arena. We are licensed to practice law just like attorneys are. We get our bar license from the State Bar Association. However, our scope of practice is limited. One of the big areas where we're limited is in actually speaking to the court on behalf of a client. However, we can do pretty much everything else. We can prepare court documents, file them, arrange to have them served. We can communicate with the other party or the other party's attorney. We can attend mediation with a client, prepare clients for hearings. And in some cases, we can actually go to a hearing with a client and assist during that hearing, but we can't speak to the court directly. And if the court does have a question of fact or procedure, they are permitted to ask the LLLT a question. Other things we can do, we can help prepare for trial, which is I've had several of those recently. Do the trial brief, prepare exhibits, the notebooks. We can attend trial and assist during the breaks, but of course we can't sit at the counsel table with the client. So most things that attorneys do, LLLTs can do. And it is limited in Washington. The practice area we're limited is family law. We can't practice in any other area of law.
Right. So I guess the term is pro se. Your client technically is representing themselves, but you can pretty much do everything other than, like you said, speak to the court to help them.
Correct. Typically, when attorneys represent clients, they file what's called a notice of appearance. And in that case, they get notices from the court and from the other side or the other side's attorney. And the other side's attorney has to communicate with that party's attorney. So in this case, the other side has to communicate still with the pro se client, although there are mechanisms by which we can ask that they communicate with a LLLT concurrently with the pro se client.
So you said you're registered or you're licensed. You got a bar number. You got the whole thing. Is this thing that's unique to Washington, or is this something that's can be found around the country?
Well, Washington was the first state to enact such a limited license. In 2012, the Supreme Court of Washington approved this new license, and the first people were licensed in 2015. Since then, other states have looked at Washington's example and have promulgated their own limited licensing. I believe the second state to do so was Utah. And I believe they are licensing I think they call them limited paralegal practitioners. Don't quote me on that, something like that. But they, I believe, can practice in family law, landlord, tenant, and possibly some sort of debtor creditor. And those are I would say the top 3 areas where low income and even moderate income need assistance is family law, debtor creditor issues, and housing eviction issues.
Yeah, you
So,
would think.
so Utah was the second, Arizona also, Minnesota, and then Oregon is going to start their licensing program in July of next year, along with Colorado, I believe, has a pilot program. All in all, I believe there are approximately 20 states right now who have either actively enacted this type of license or are working toward that.
You mentioned that you can practice most legal matters in under family law, if it's considered
Correct.
a family law case.
Yes.
Family law is sometimes a kind of an amorphous term. So can we talk about that a little bit in terms of the types of family law cases that you can practice in? Because I know, some people consider family law everything from surrogacy to adoption to guardianships to estate planning to divorce.
Right. So you mentioned several of the areas where LLLTs are not permitted to practice: guardianship, adoptions, surrogacy, dependency cases, those types of things. The more common: divorces, establishing parenting plans for unmarried couples, establishing child support, paternity cases where testing needs to be done to determine who a father is, domestic violence cases. Those are the big ones. And then within family law, within those types of cases themselves, there are certain issues that we cannot address. Some of those being if a client or a spouse is in the midst of a bankruptcy, we have to refer them to a bankruptcy attorney to give instructions on how we would deal with that bankruptcy within the context of the divorce. We cannot take on cases where there is a question of jurisdiction under UCCJEA for a parenting plan. We cannot deal with cases where they're under the Indian Child Welfare Act. If a child is part Native American and a tribe might have a say in the parenting for that child. And then other issues might be we cannot take on a divorce where there is a division of a business. We'll have to refer that out to an attorney, and then when the issue is resolved, that attorney can provide the LLLT with information on what to put in the divorce orders, so that we are within our scope.
And tell me if I'm assuming that all of the different, I call them iterations of divorce, legal separation, separation of a registered partnership, all of those things fall into the family law types of cases you can do?
Generally, we cannot. That's another question. For unmarried couples, we cannot assist with what's called intimate partner relationships. So where there's a need for division of property between unmarried couples, we can't assist with those because those technically are merely civil cases.
Yeah, I was going to say those really are just civil cases. They don't even fall into that. You mentioned that on some of the stuff that you can't do on your own or just initially, you can work with an attorney. And an attorney can work on some of that stuff, and then it can come back to you and you can help? Yes.
So we mentioned some of those things: bankruptcy, resolving a jurisdictional issue. Another common example is we cannot prepare qualified domestic relations orders, or even refer to them in a case until a client has met with an attorney and determined, what needs to be done with the division of a retirement plan or a pension.
Right. Yeah, that makes
so
sense.
yes, we do work with attorneys. Another instance where a client might want to move to an attorney for part of the time is when they have a hearing coming up, and they do not feel comfortable speaking on their own behalf in court. What I typically do for my clients during hearings is I'll prepare talking points. I will coach them on what to expect. We get on in Washington, most of the counties have Zoom hearings, and so I'll get on the Zoom platform with them. We'll establish a chat on a chat app, and so I can confer with the client while the hearing's going on. And often before the hearing, they have many questions because there are other cases going on, and so they'll have questions about things, as to what they should do. And so it's very interactive. Again, I can't speak on behalf of a client, but I'm right there coaching with them, and that's most hearings. There are very few hearings that we cannot assist during. So if a client doesn't feel comfortable speaking on their own behalf, for example, I've had a client with ADD, and they just get tongue-tied and they get nervous, and being nervous is very common. Most clients are nervous. So they could have the option of having one of our attorneys file a limited notice of appearance just to appear at that hearing. And then when the hearing's done, they'll withdraw and then go back to my services, which are the behind the scenes services. So that's an option. Or if they're going to trial, I can do all the pre-trial work, keep the attorney apprised of what's going on, even have the attorney review and have some say in the trial brief. And then the attorney would actually represent them at the trial.
Right. So, another dumb question. The place that LLLT fits is sometimes, I'm thinking like, well, why don't I just hire an attorney to do the whole thing? There's the reason that you guys are doing what you're doing, I would imagine, has something to do with, saving the client money.
Yes. So the license was created primarily to assist moderate income clients. With low income clients, often they're at 125% or below the poverty level, sometimes receiving public benefits. Often they have access to legal services agencies. Legal services agencies receive federal grants and state grants to help those who are at the poverty level. But for those who are above that poverty level, they have fewer resources. And so the license was created to make it more affordable for that niche of litigants to be able to afford legal services. So we're talking generally above 200% of the federal poverty level. And as an example, if I have a client, a single mother who's got 2 kids in her household, 400% of the federal poverty level is $7,320 income for a family of 3. So it seems pretty high, but when you're talking about hiring a lawyer at $350, $375 an hour, and that $7,300 was gross income, so conceivably $5,500 net. Supporting a family of 3, once your mortgage is paid and all your bills and your credit cards, if you're in debt, there's not much left to be able to afford an attorney. And so our LLLT rates are usually quite a bit less than attorneys. I generally say they're at least half of what an attorney's rate is, and sometimes as low as a third of what an attorney's rate is.
If I'm just not sure. I've got a divorce coming up, and I'm not sure if what I need to do, how to do it, how if I can afford it. Um, could I come in and talk to you before you even we hired you uh, to kind of go through, and you can tell me yeah or no or yes and no on what you could do to help them?
Absolutely. I have consultations with clients first to determine what their issues are and whether any of their issues might be outside of my scope. Um, so I ascertain that. I do a analysis of what their income is and what my rate would be, because I do try to charge on a sliding scale based on income and household size. And I go over what the procedure is for whatever their particular action is, discuss what the predicted timeline might be. We talk about whether we'd want to do discovery, which is an exchange of information, formal exchange of information, whether they might need a motion for temporary orders in the interim if it's a contested action and it's expected to go on for months, 10, 12 months. It can be about a year before you get a trial date. And so often a client will want to have temporary orders entered in the interim in order to get potentially child support, set a parenting plan, maybe get some spousal maintenance, maybe divide some property initially. So we
You
go
can
over
help
that
with
in
all
great
that.
detail. Yes.
The discovery one um, really jumps out because I know that a lot of people I've talked to who are kind of, especially if they're not the ones who file, the first thing that sort of kind of hits them is this discovery request, and they need, there's a list of 82,000 things, it feels like, and that can be pretty daunting, but they can come into you and you can help them with that.
Yes. And in fact, I've had clients just hire me to help them put their discovery together, their discovery responses, or send discovery. You might have a spouse who has had control of the couple's finances, and a client doesn't have access to any of that. And there needs to be some transparency as to what assets are owned, what debts are owed, before you can even move on to any mediation or really to any sort of finalization of the case.
Yeah. Is there anything I should be aware of if I'm going to hire you? I know one of the things you talked about was actual physical representation in court, um, or or what about getting things from the other attorney or getting things from the court? Um, I can't come in and rely on you. I'm taking it to make, to receive court documents, to receive court orders, or can I?
Yes, you can. So what I do when I first get into a case, assuming that it's been filed or at the time of filing, I will have the client file a notice of appearance pro se. And then within that notice of appearance, I also list my contact information, and it requires that the court and the opposing party or the opposing party's attorney communicate with both of us concurrently. And so that kind of solves that problem. And the courts in Washington, at least in the big counties, they're very familiar with legal technicians' work, and I very routinely communicate with the court on behalf of my client. I always CC my client because, again, as you said, the clients are technically pro se and they should be receiving, firsthand communications.
Yeah. But that actually, I mean, that I don't want to call that a way around the rule, but it kind of is a little bit, and helps. At least it would help me um, feel better that, oh my God, I missed something.
Mhm.
I like that. I like that a lot. Um, so the advantages of an LLLT in a family law case, we've talked a little bit about those. Have we missed some of the advantages that you see in an LLLT matter versus going with a full representation of an attorney?
Well, we talked about the cost. Again, the cost is prohibitive for many clients. I've had many clients come to me after they've already had an attorney and they've already spent 10, 20, in some cases, I've had a couple of clients who've spent $75,000 on attorney and they are still not through the trial stage. So cost is the big one. Secondarily, I guess if clients don't have very complicated cases, it may not make sense to hire an attorney and spend $350 an hour doing an uncontested divorce. Why not hire a LLLT if there are not any of those issues that are outside the LLLT scope? Another thing that I found from clients who are coming to me after having had an attorney is they have gained more of an understanding of the law and the procedure when they come to me, because I empower my clients with that knowledge. I thoroughly explain the law. We will go over a statute in detail, showing the elements that they need to prove for a specific issue. We'll go over the procedure in detail. I'll send them the court rule on whatever it is. For example, a motion for reconsideration. This is the court rule. This is what you need to do. I found that they really appreciate having the knowledge of the law and the procedure, rather than if you have a lawyer. I think a lawyer is less inclined to spend the time explaining that all to them, and rather they just do it. Ask for permission and do it.
And that kind of makes sense. I mean, an attorney is also trying to save them some money, and knows how to do it quickly, and then does it. And while that saves them money, you're right. Sometimes someone can feel kind of out of it because they don't really know the why of what's going on. So you mentioned uncontested. On uncontested divorces, you also see this a lot. Well, it's uncontested. All I got to do is file. It seems to me that those people could use you.
Yes. Yeah. Depending on what county you're in, things can get extremely complicated. Knowing how to note a hearing, and especially over the past couple of years during COVID, when things changed so dramatically about how to go about doing that. We went from all in-person hearings to Zoom hearings, back to some hybrids. And during that time, especially in King County, the rules changed every other month. And so as a LLLT, I had to really stay on top of that and, be knowledgeable of that. Whereas pro se people, sometimes they don't have anybody to help them. Now, in the bigger counties, there are family law facilitators at the courthouses who can help. However, they do charge sometimes. Every time you see them, around $30, let's say. And if you don't get all your questions answered initially, you end up having to go back. And I have had clients who have gone back to the facilitator 3, 4, or 5 times and haven't gotten a resolution to their case. So having someone who's there from beginning to the end of an uncontested case is very valuable.
We're coming up to time, but just a couple things. One, you kind of hit on it. Why LLLTs exist and one of the original kind of reasonings, and it was because of the difficulty of getting representation. And can you just kind of talk a little bit about that? Because it's a real problem, the amount of people today who aren't able to get representation. And I guess on that is the state of Washington at least thinking of going outside of family law to expand this at all?
Okay, so two-pronged question. The license was created following the Washington Civil Legal Needs Study regarding low-income people's access to legal services. Now, that was in 2015, and at that time, about 76% of low-income people did not get the help they needed to solve their legal issue. And actually, 65% did not even pursue any help at all. They either didn't know it was out there, or they just figured they couldn't afford an attorney. So really, we're only talking about 11% who actually sought help and got help. And that civil legal needs study does not even take into account, as we discussed earlier, the modest means people. This was people at the federal poverty level. What was the second part of your question again?
Oh, just whether or not they're thinking of expanding. You said it's just all family law right now.
Okay.
Into other types of law.
So unfortunately, in 2020, the Washington State Supreme Court sunsetted the LLLT license. And by sunset, I mean they are not allowing any other LLLTs to become licensed. Those who were licensed were grandfathered in, and so we can still practice. I do serve on the Washington State Bar Association LLLT board, and one of our tasks is to sunrise the license. So we will be working on trying to convince the Supreme Court that it is a valuable license and it should be reinstated. Part of being on the LLLT board before this was sunsetted was exploring other areas in which LLLTs could be licensed, other practice areas. And so we did look at housing, we've looked at administrative law. The chief administrative law judge in Washington actually was very supportive of LLLTs assisting at administrative hearings. And by administrative, I'm talking employment law, public benefits, administrative child support hearings. Right now, administrative law, most administrative law hearings, a layperson can assist. And so it makes complete sense that a LLLT should be able to assist.
Yep.
So that would, if indeed the license is sunrised at some point, we will again attempt to expand into other areas of law.
Well, it seems like it's really doing a great service, and that should be considered. Thank you so much. We have come to the end, always too quick. And so I just want to thank you so much, Christy, for kind of talking about the role of the LLLT and not just the role, but the importance of it, and doing it in a language that we can all actually understand. So thank you so much today.
You're very welcome. Thank you for inviting me.
Oh, I will invite you again.
Okay.
And everyone else, thank you for joining us today. And if anyone has any further questions on today's topic, you can post it here, or you can give us a call and we can get you connected with Christy right away. So until next time, stay safe, stay happy, and be well.